Chavez Arnold.
There you go. All right. So last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right. So, Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statement.
What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender, and they borrowed from me.
All right, folks, buckle up, because today's courtroom circus features not one, but two sovereign citizens who think credit cards are optional and debt is imaginary. We're heading to Michigan, where Arnold Chavez, self-proclaimed American state national, tries to argue that he's the lender and J.P. Morgan Chase owes him money. Yeah, you heard that right. It's the classic strawman defense, a favorite among internet gurus who think YouTube videos can replace contract law. In this saga, we'll watch him try to turn financial fraud into philosophy, while the judge, who's seen every flavor of nonsense, isn't buying any of it. But trust me, the best part is still coming. You'll see how fast this courtroom patience runs out when reality hits fantasy.
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right, Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Where did I? 1 second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating. So.
I will get that out
motion for
right
summary
away. I had it
disposition.
prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2020.
And there it is, the first red flag of every sovereign citizen encounter. They demand access to internal corporate accounting records. This is where delusion meets data privacy. Arnold genuinely believes that if he can inspect Chase Bank's internal books, he'll somehow find proof that his debt doesn't exist. What he doesn't realize is that these massive corporations don't just hand out trade secrets because someone watched a 3-hour UCC redemption seminar online. Judges see this move constantly. It's the courtroom version of a child saying, "I can't lose if I change the rules." The only thing he's auditing here is his own.
Still, Mr.
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So,
Now, this is where it gets almost poetic. He admits he used the credit card, admits there's a balance, and still insists the bank borrowed from him. This is classic SOVCAT economics, upside down, inside out, and allergic to math. The way they spin it, your signature supposedly creates value out of thin air, and the bank magically becomes your debtor. But let's be honest, if that were true, Chase Bank would owe billions to TikTok users with fountain pens. The judge's patience is impressive here, because most people would have already ordered a mental health.
So what do we need discovery on this? What, Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see There was an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's account estate.
Yes, the infamous I am the lender defense, the holy grail of sovereign delusion. According to this logic, when Arnold signed up for a credit card, he was actually financing the bank. Never mind the fact that he's the one buying groceries on credit. He thinks he's some kind of hidden financier of global capitalism. The phrase, personal security, here is code for his imaginary trust fund in a parallel universe. Sovereign citizens love these phrases because they sound legal but mean absolutely nothing. It's like calling monopoly money Federal Reserve.
An account stated, it clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what.
Just like that, the judge does what judges do best, resets reality. No long lectures, no arguments, just a simple summary disposition, hearing scheduled. Translation? The court's basically saying, we've heard enough nonsense. Let's finish this on paper. That's how most SOVCT cases end, quietly, decisively, and completely against them. Because once you strip away the buzzwords and conspiracy fluff, the math still says you owe the money. The law doesn't bend for internet pseudo-legal theories, no matter how.
Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes.
Okay.
I am yes, here for that matter to handle the matter that's at hand.
Okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a benefit.
But it gets even better, because apparently one courtroom embarrassment wasn't enough. Arnold's back again, this time with another credit card company. Same man, same theory, new creditor. It's almost impressive how consistently wrong he can be. What's fascinating here is that these individuals genuinely think each courtroom reset is a chance to educate the system. They see themselves as legal prophets, not repeat debtors. The only thing they're really manifesting is a growing collection of unpaid judgments, and maybe, just maybe, a YouTube compilation like this one.
Takes any position, Mr. Gunderson, is the city taking any position on the representation of Mr. Moore in this matter? I don't even know if you're appearing on behalf of the city in this matter.
Good morning, Your Honor. Will Gunderson, prosecuting for the city. Your Honor, the city does typically appear for the contested hearings in which officers have been subpoenaed.
Was an officer subpoenaed in this matter?
Yes. Your Honor, the officer is present Officer Berglund is here. Your Honor, my position at this point is to request a short continuance in this case. The basis being I rely on the Judicial Information System, or JABS, review that information relevant to the particular case. Within the last 20 minutes, JABS database has gone down. Oh.
And
I see that now.
do you take a position on the representative of Mr. Moore appearing in his stead this morning for purposes of the hearing?
Your Honor, ultimately, the city would defer to the court on whether or not the individual is present is allowed to act on behalf of the defendant. To cut to the chase, Your Honor, this sounds like it might be a sovereign citizen type of situation. I don't know if the individual that is seated here is in fact the defendant, or if he is a completely separate person, separate and apart from the defendant that was pulled over at the time this incident took place. So that is a red flag, so to speak, or a question mark that does get raised in the city's mind, for which the city does believe that a further inquiry by the court may be appropriate. But ultimately, Your Honor, with regards to any representation, city will defer to the court.
All right. Thank you, Mr. Gunderson. So, sir, I'm going to ask you to identify yourself for the record, please.
I am one of the people.
I'm sorry?
One of the people.
Okay. Are you or have you been previously named or identified by the state of Washington as Sherman Moore?
I am not Sherman Moore,
Okay.
the entity in which you speak of.
And of course, no SOVCIT saga is complete without a dramatic excuse. This time, it's Xfinity took me down. To be fair, tech issues happen. But somehow, these folks always find a way to turn basic inconvenience into constitutional crisis. The judge, to his credit, handles it professionally, verifying the excuse, maintaining order, and keeping the case on track. It's moments like this that remind us, the real strength in the courtroom isn't the loudest voice or the fanciest pseudo-legal